Linda O'Brien. I am one of the lawyers in the Jelinek Ellis Gluckstein Sexual Abuse Group, and I am going to present today on assisting defense lawyers in assessing the plaintiff's case. This is primarily a presentation for plaintiff lawyers. I know that we do have some defense lawyers that are joining in, and hopefully they will participate at the end in terms of if they have any other specific insight to assist plaintiff lawyers in ensuring they're providing everything to the defense lawyers to make sure that the defense lawyers can do their job. So just a little bit about my background. I was a defense lawyer for just over 26 years before switching to the plaintiff side. I did work in a lot of areas exclusively for insurers. So motor vehicle, sexual abuse, occupiers liability, a little bit of med mal stuff, and directors and officers liability. And I managed a firm for a number of years in terms of about 20 to 22 lawyers working also exclusively for insurers. I was also the main client contact for the last probably decade of my career as a defense lawyer. So a lot of insight in terms of what clients need. And when I say clients, I'm talking about the insurance clients from their defense lawyers and how the plaintiff lawyers can really assist in doing that. I've also mentored a number of lawyers over the years. So I think I have some information that is probably going to be old news for anybody with seniority that's on the call, but hopefully will assist some of the younger members of the bar in terms of making sure they're getting exactly what they need to get for their clients, on both sides. So my objective today is to basically provide you, and that's primarily plaintiff lawyers, with the best practices to ensure that you can obtain the optimal value for your client. And critical to this, like I've mentioned, is ensuring that you can make the defense lawyer's job as easy as possible. So how do we go about doing that? Let's talk about before the claim even gets to a defense lawyer, because there are some critical steps there that plaintiff lawyers need to take advantage of to make sure that you're doing the best you can for your client and putting your client's best case forward. So one of the top things, if possible, don't even let it get to a defense lawyer. If you can, sorry about that, if you can settle with a adjuster or claims examiner, I'll use those terms interchangeably during this presentation, then do it, because that not only gets your client a much quicker resolution of their case, but also allows you to take advantage of working directly with that adjuster or claims examiner. Great people to get to know and to build relationships with, because if they know who you are from a plaintiff perspective, then the next time that you have a case with them, things will work probably a lot more smoothly because there's that relationship that's already been established. So before your claim gets to a defense lawyer, you've got to have all of the key documents that you need to support your client's claim. Once you have those records, then send out that notice letter, and almost always you're going to receive a response from that adjuster who's been assigned to the claim, and they're going to have an interest in talking to you and learning as much about the claim as they possibly can. So instead of just sending out that notice letter or immediately serving a statement of claim and saying appoint defense counsel, stop for a second and see whether or not your claim might benefit from staying with the adjuster at that level. I can tell you, as both a defense lawyer and a plaintiff lawyer, loads and loads and loads of claims settle at that level before going into the actual litigation phase. So call them, discuss the file with them, give them the documents they need, because they too need documents, and you're not wasting time, because all of those documents are ultimately going to be forwarded to the defense lawyer if the case is going to move to that stage in any event. So provide them with those key documents. The adjuster's role is to review all of those documents and to create their own initial assessment of liability and damages. They know what they're doing. They know how to assess files. And if they know right out of the gate that the file is going to be something significant or definitely beyond what their expertise is, then they will look to move that file up the ladder in terms of the next level of claims examiner. And then you're going to get into a position where the person's going to be able to hopefully get you the right authority to settle that case if you can, or to allow you to narrow the issues if you can, and to eventually move on if you're not able to settle at that level. So just looking specifically at what the role of the adjuster is before defense counsel is appointed on a file, like I said, they have to review and assess the case. And if you're providing that crucial information on liability and damages, then it gives them the needed material to make that assessment. And that assessment then is reviewed by their manager. And the manager will then determine if it stays with that adjuster or if it needs to go to a different level. So an important thing to note when you're dealing with the insurance companies, just like in your own firms and practices, there's going to be different levels of seniority of lawyers, just like there's different levels of seniority with claims examiners. So you want to make sure that you're providing enough information and documentation right out of the gate to get that claim into the hands of the right level of claims examiner. If you just meet with your client, immediately issue a claim, and send the claim out without any documentation, despite what might be alleged in the claim, and assuming it's a fairly generic claim, then your claim is going to probably end up at the lowest level of the claims department, and it's going to stall out there. It's going to have a defense lawyer appointed that's likely the most junior of defense lawyers, and it's going to stall out again there because you have not provided any of that critical information that they need to make that assessment. So frankly, just issuing a claim without getting that information and sending that information is going to delay your file and not put it into the hands of the people that need to have it. So for example, you know, a lot of insurance companies, if we're looking at motor vehicle accident claims or slip and fall type claims, are taking defensible positions, which means, you know, they think that your case in a motor vehicle accident claim, for example, is not going to pass threshold. So if you're sending that claim in with no documentation, then it is immediately identified as a defensible case right out of the gate, despite what your claim might say. So that is creating a bit of a barrier for you, because you then have to go back and take those steps to get all of that information, to build it up, and then it has to go through all of the steps to move forward. So the other roles of the adjuster are to settle the claim if they can at the beginning. When they are assessing the case, they have to work on what the reserves are going to be for that case. So the adjuster and their claims manager will work on reserves. Reserves are probably one of the most important things to an insurer because it sets what their exposure is going forward on your claim, and in addition on all of the claims that they have within their claims department at a specific time. So the adjuster and the manager will work on what that reserve should be, which is basically another word for the assessment. So what they realistically think the worth of that case is, the value of that case, and they will set those reserves. To get those reserves moved can be difficult, and we'll talk about that later in terms of what's needed to make sure changes occur. Like I already said, they're going to also ensure that the file is at the proper level of adjuster or claims examiner when you first provide them with notice of your claim and your documentation. For the most part, during this assessment, I'm going to assume we're talking about claims where you are actually providing disclosure and relevant disclosure prior to anything happening. For cases where you're not doing that and you're just issuing the claim and sending it in, like I've indicated, you're just bogging down your file at not only adjuster levels, but at defense lawyer levels, and creating longer timelines for your client. So, like I already have mentioned to a certain degree, how the claims department works in insurance companies, it's going to be very, very specific to each company, but a lot of them have some very general practices that are there. Like I said, there's going to be levels of adjusters in each of the companies. Those adjusters come with potentially their own levels of authority, so they can only handle claims up to a certain dollar value. And then after that dollar value, it has to bump up to the next level. They are assigned to your claims based on what you have provided. So again, as I mentioned, if you provide nothing, it's going to go in at the bottom level of the claims department. If you've provided substantial documentation that justifies, for example, that your claim is catastrophic, or that there's going to be very significant liability issues for the defense, then that is going to be flagged and hopefully moved right up the chain before it gets anywhere else. And again, just providing those key documents is going to ensure that you're starting out at the right level and not wasting time. So what are those key documents? Well, there's a lot of them, and everybody knows primarily what they are, but they're things you need as a plaintiff lawyer to prove your case before you even begin. So after that initial meeting with the client, you really should be collecting all of the documents. I can't tell you how many times from a defense perspective where new files would come in, and if they were a motor vehicle accident case, for example, they wouldn't even have the MVA report, which is the most critical piece of document that the insurer needs and the lawyer needs, because as the defense lawyers know, the first thing we do is look at that MVA report to see what the police checked off in terms of whether the person was insured at the time, what level of driver they were at the time, and whether there were any breaches of the policy based on that information. So that MVA report is the most critical document and can impact whether or not there's even coverage available to the claim that you've issued. So obviously in your best interest to make sure as a plaintiff lawyer that you've obtained all of the police records that you can get before you even issue that claim or send that claim out, because again, you need to address what those hurdles are going to be if, for example, you're dealing with a defendant that's a G1 driver and intoxicated at the time, or breaching any of their requirements to drive at a G1 level. Similarly, with a slip and fall. If you don't have those initial incident reports, then you should have them, because that's going to obviously give you a lot of information as to whether what your plaintiff has told you is lining up with what those incident reports say. And if those incident reports are not lining up with what your client is saying, then you clearly have to speak to your client about those differences to understand why they might be there, and to ensure that you have a case you can go forward with. So any liability documents are very important. The MVA report, any witness statements from the MVA report, also really important, because again, lets you assess liability out of the gate. Do you have a clear liability case? Do you have a really difficult liability case? All of these things are important because they're going to impact what you can do with that adjuster or with that defense lawyer early on in the file. The other thing that's obviously very important from a liability perspective is there a criminal conviction? Is there a Highway Traffic Act conviction? Was evidence given in the Highway Traffic Act by your client or by other witnesses? Again, is there any contradictory information that you need to know? Similarly, for example, in a sexual abuse case, is there a criminal conviction of the perpetrator? Because that is going to have a huge impact on liability, particularly if there's an institution involved. So moving on to the key damages documents, obviously, the most important things are clinical notes and records of the family physician for at least 5 years before, up to the time of the incident. In a sexual abuse case, we're going to want clinical notes and records for as far back as we possibly can get, to make sure that we have a good idea, because in a sexual abuse case, for example, you need to recreate the plaintiff's life basically from day one, particularly if you're talking about a historical abuse case. OHIP summary is also really important. Any treating practitioner's records in terms of who they're seeing currently, if they're being referred to any specialists, if they're going for, massage therapy or physiotherapy, all of that's really important at the front end to understand your claim before you start presenting it to an adjuster or to a defense lawyer. If you don't understand your claim before you're doing that, then you're not going to be able to have any fruitful discussions with those other people on the other side of the case at any stage of the process. Other things that are important are tax returns as far back as you can get them, school records, if those are applicable in terms of an OSR or university records, anything like that is going to be really critical and important. Those are the documents that, as a plaintiff lawyer, I really recommend you get before you take any steps with the case, and you review all of those, and at least you've got a really good idea of what your case is about, and you can develop your theory of the case and work towards that case. You can understand the risks in your case, and you can, after you get those records, identify the additional records that you'll need to start requesting. But at least this will give you a great head start and will give the adjuster that receives them an ability to properly assess that case. And if it goes on to a defense lawyer, gives them that opportunity as well. So all of these documents are super important for that main reason, for you to assess the case and for your other side to assess the case. When you can't settle with an adjuster, then it's still, anything that's happened with that adjuster is still important and still something that the defense lawyer will look at when they receive the file and they go through all of the adjusting notes, because they do receive the adjusting notes and they will see what has happened up to that point. So if there were any offers that were exchanged at the adjusting level, those are going to be something that are critical as soon as the defense lawyer looks at the file. So usually if there has been discussions with adjusters, then the defense lawyer will be given a heads up that there were discussions. And at least from my perspective, when I was doing the defense work, I would look at those offers immediately to see where they were, to see how far apart the parties were. And I would keep that in mind when I'm reviewing that disclosure, because when I'm reviewing that disclosure, I'm looking at it to assess the case. And if it looks to me like, hey, we could probably get this shut down really fast. And the reason it didn't shut down is because perhaps the adjuster missed something when they were looking at it, or didn't quite account for the liability issue in the correct way, or even that maybe plaintiff counsel wasn't aware of some case that had recently come out that impacts the liability. Then it's really good, because as a defense lawyer, you can call up the plaintiff lawyer and you can try and get that really early resolution of the claim there. You might be able to close that gap and and uh, and and move on and not have to deal with going through any of the other steps in litigation. Plaintiff lawyers need to know that insurers are interested in getting rid of files. And I don't mean that in a bad way. I mean it in the sense of moving files along and through the system quickly, because they've got huge pendings and they want them to move. They're not going to move on a nuisance level. So they're not going to move a file just because you've issued a claim and you want $5,000 or $10,000. They're going to move them with principle. And if you are producing the documentation that you need to produce, and what I've indicated currently already, then your file is going to get attention. Your file is going to get reviewed properly. And more importantly, your file is going to get assessed, and there'll be a look towards cooperating with you to see if that can be closed early and to see if you can avoid going through all of the steps, because frankly, going through all of the steps costs money to the insurer. And if they can get that early resolution and not pay the defense lawyer to go through every single step of the litigation, then that's a win-win for both sides. So when you can't settle with the adjuster and you issue your claim, there still may be an opportunity for the new adjuster, because often there is a new adjuster. So the person that you've been speaking with, that may change and move to a different level once you issue your claim. And if they call requesting a waiver, then do it and grant it, but grant it for a short period only, in the hope or on the condition that they then have a conversation with you at the end of that 30 days to see whether or not there is a further opportunity to resolve the case. So moving on, when it can't be settled with the adjuster, how is the level of lawyer determined? Well, based on what I've talked about, the level of lawyer is determined given what you have provided to date with respect to your client and your client's case. Sometimes the level of lawyer is determined by the plaintiff lawyer that's on the file. So if it's a really senior lawyer on the file and maybe they have not produced as much documentation as they normally would, but the company has enough files with that person to know that they will build it, then it might get bumped up. But for the most part, the level of defense lawyer assigned to your case is going to be in conjunction with what you've produced for your damages and liability on the case. So once the defense lawyer is appointed, their job is to review the file that's provided to them from the insurer, and the insurer is going to provide them with every single piece of paper that you have already provided. And they have to provide a preliminary opinion on liability and damages. And generally, they have to do that within a very specific time frame, typically 30 days. So super important because it's the first time that defense lawyers setting eyes on it. And again, I can't stress enough, the more documentation that that lawyer has in their hand at that time, not only the quicker can they get that opinion out, but the quicker they can receive instructions from their client, the insurer, on settlement authority, what else might be needed, or whether they just have to move it to discovery to get a more fulsome idea of the case. So overall, having all of that disclosure provided in advance lets that lawyer make probably a much more accurate assessment of the case as possible right out of the gate. Usually after that initial letter has gone to the insurer, there's going to be a call between the lawyer and the insurer, the defense lawyer I'm talking about. And that's an important call because, again, they get to discuss the pros and cons of what they know about the case at that stage and to determine what the next steps are going to be that they take. At that time, there's usually going to be a request from the lawyer for any additional disclosure that they need. But if you've already identified all of those things you need by reviewing all of your initial documents in any event, you should have already been requesting that, and you know that it's coming through and that you're going to be able to provide that really quickly. As you provide additional documentation to defense counsel, the defense lawyer has an obligation to their client to update that initial opinion that they gave as new information is received. This is really a critical step of the defense lawyer, and one that I used to talk endlessly about to new lawyers. So you're always going to take that initial opinion and you're going to build on it. For the initial opinion, there might be, 10 pieces of documentation that you looked at, but as that file grows, we all know it expands and becomes many, many more. And anything that is going to change that initial assessment on liability or on damages has to be reported to the client. And again, when I say client in this context, I'm talking about the insurer. So it has to be reported. And the insurer then makes the decision whether or not it is increasing its reserves on that case. So as you're receiving new disclosure, being a plaintiff lawyer, you want to make sure you're getting that out to the defense lawyer in a really timely fashion. There's also generally a practice in place with the instructions that are given by an insurer to defense lawyers that they need to reach out to you as the plaintiff lawyer within about 30 days of receiving the file to see if there's an opportunity to resolve the case. Often there's not at that stage, but occasionally there is. And again, if you can do it, why not try it? And at least by having the defense lawyer reaching out or you reaching out to the defense lawyer, it helps you build those critical relationships that are so important to your reputation and to your means of practicing as you move forward. So if you're seen as, a reasonable and diligent lawyer coming out of the gate, and this applies on both sides, then the process of the litigation is probably not going to be as tumultuous as it might otherwise be. So again, at this early stage, you want to look as a plaintiff lawyer at whether or not the case can be resolved. And if you can't, why can't it? Is there something that you're waiting for? Is there something further that you need to do? Is there something that defense counsel has indicated to you they need in order to provide something that their client has requested or something that will change or alter their liability or damages assessments. And if that's the case, then get it and do it as soon as you can. Keep in mind, defense lawyers in this day and age have extremely tight timelines that are set by their clients in terms of when things need to be completed. So there's timelines on, that initial assessment, there's timelines on pleadings, there's timelines on when you have discoveries, when you schedule discoveries, when you bring motions, when a mediation is held and when you set a matter down. All of those things are filled with timelines. So as long as you are giving that defense lawyer as much information as you can to move the case forward, then you are helping them meet all of those timelines. Because when they can't meet those timelines and it's your fault, it's just going to create a spiraling effect in terms of you being swamped with undertakings motions or motions compelling you to serve an affidavit of documents, all things that you want to avoid because they waste your time and they waste the defense lawyer's time. So I think what's really important, and not everything's going to work all the time, but you want to try and work with that opposing counsel as much as you can, as opposed to working against them. And there's going to be situations where they're just not very cooperative, and that could be on both sides. But if you have a standard practice of the way you manage yourself and the way you handle yourself and the way that you run those files, then just stick with it and push it through all of those stages. And I'll give you an idea later on why that becomes important, especially from a plaintiff perspective. So I think one of the key things to note is that the faster the file moves, the better for everyone. And it gets you to that point of resolution much faster. Or if you can't resolve, it gets your case set down and moving forward on those trial lists much quicker. And we know that those are really bogged down. Some of the biggest frustrations for defense lawyers in terms of dealing with plaintiff lawyers is when the plaintiff lawyers delay things. And generally that's because they're not supplying that disclosure that's required. They're not, or the disclosure they've provided is outdated by a couple of years. It's really, really difficult. So if I'm a defense lawyer and a plaintiff lawyer sends me a disclosure and the disclosure was last updated 4 years prior, it's not going to help me in any way, shape, or form, because how on earth can I assess the validity of any kind of economic loss claim when I have no idea what that person's currently doing and what they've been doing over those 4 years? Like, have they graduated from school? Has school been delayed? Have they lost their job? Are they working full time? All super critical issues, especially when you're dealing with economic loss. Defense lawyers are really frustrated when they have to bring undertakings motions. So again, as a plaintiff lawyer, you finish your discovery, send your undertakings list off to your clerks and get them working on that right away, and start sending those undertakings through as you receive them. You don't need to be updating your affidavit of documents every single time you're sending through documentation and satisfaction of an undertaking. That can be done later on at more critical stages. Just send the documents through. You don't have to wait for a big pile of them to send them through, because honestly, like I said, depending on the content of those records, they might be really critical to defense counsel in terms of having to update that assessment from their end for their client. The other area that's extremely frustrating for defense lawyers is when they need to bring motions to compel plaintiffs to produce an affidavit of documents. Again, for plaintiff lawyers, don't supply affidavits of documents the night before a discovery. There's a good chance you won't be going to discovery because it's too late. You should have your initial affidavit of documents ready from the day that you issue that claim. It should be ready to go and sent off to defense counsel if it has not already been sent off to the claims examiner before then. Another frustration is, of course, if the pleading is too generic, because then you will be bogged down with a demand for particulars. And no plaintiff lawyers like receiving demands for particulars because then they have to respond to them. Oftentimes, especially I'd say in the sexual assault context, it's there's not a ton of, there are a lot of particulars put into the statement of claim, and we'll still get them because people want even more information. You know, that's just what it is. We can't put in every single thing or we'd have these massively long pleadings. But if you're dealing with, you know, some of the more generic type MVAs or slip and falls, that kind of thing, you know, as many facts as you possibly can is helpful just to avoid those frustrations. From a defense perspective, also really frustrating if you're avoiding the defense lawyer's calls or inquiries about settlement discussions. Just pick up the phone. And if you don't want to engage in settlement negotiations at that point, then tell the defense lawyer why you're not. You might be waiting for documents, you might be waiting for something crucial in terms of your client's health to be addressed. I mean, they might need some kind of surgery, or they might be in the middle of a mental health crisis and they can't provide instructions at that moment. So just be honest with them when the defense lawyer is looking to resolve your case, because, you know, if you've provided as much as you possibly can right out of the gate, there may be more than sufficient information there for that defense lawyer to want to settle your case right then, and because they know it's only going to get worse. So if you've got a defense lawyer calling you wanting to settle, it's usually because they understand your case, they understand the exposure from their end on that case, and they want to deal with it. Again, frustrating for a defense lawyer is when the insurer adjuster is asking for updates on the file and they can't give them any because you haven't provided documentation. That's where it leads to those motions that, you know, really should be unnecessary. Another frustration is when you're building a mountain out of a molehill. And for plaintiff lawyers, again, understand your case, understand what it is, understand what the value is and what the risks are. If it is a case that you know has a lot of problems and is going to have, you know, a fairly minimal value, then don't start papering it with a bunch of unnecessary expert reports, because, you know, there's consequences for the plaintiff lawyer in doing that in terms of those disbursement expenses, and a very good chance that defense counsel is not going to want to pay for any of those. And your, you know, your offer is going to be some small all-in number and make it much more difficult to get those instructions. And I think I've talked about this a lot already, which is, if you're going to, as a plaintiff lawyer, just follow the standard litigation plan, which is you issue your claim, you wait for the defense lawyer to ask for specific documents, you get those documents, you go to discovery, you know, and then you move on at those stages, then you're missing opportunities along the way to make things faster, quicker, and frankly, easier for your plaintiffs. So just keep that in mind. And probably one of the biggest frustrations is when you're obtaining unnecessary expert reports. I'm going to chat specifically about expert reports, but when I talk about unnecessary expert reports, it's sort of in the context of what I've just mentioned, which is if your case is really not that great, and you know it's not that great, but you go out and you get the same economic loss report you've always got from the same person you always get them from, and the same medical legal that you always get from the same person you always use, then you're really, and those reports are saying the same things they always say, particularly with the medical legal, that the defense lawyers see from that same expert every single day, then you're probably obtaining unnecessary expert reports. So really think about that before you start pursuing those types of reports. And let's talk specifically about expert reports. So question number one for a plaintiff lawyer is always, do you actually need them? So are you able to get your case resolved for what it is actually worth without getting the expert reports? Because why wouldn't you take advantage of that and save your plaintiff those additional expenses? Again, don't get hung up on those steps of litigation. If you can settle, take that opportunity and do it. Now, I will caution with that, because when I was a defense lawyer, and I'm seeing it now as a plaintiff lawyer, insurers were really trying to cut down on expenses, and one of those was funding or having to pay as disbursements expert reports. And so insurers were saying they don't want them and they don't need them to settle a case. But you have to, as a plaintiff lawyer, really look at whether that's going to be helpful to you. Because if you get to a mediation where you don't have those reports and they don't have reports, and they're taking the position as defense lawyers saying, well, you don't actually have something to substantiate those allegations and claims you're trying to make, then how many months have you just wasted? So be really cautious when defense lawyers are asking you not to incur the expense associated with getting those reports. And, you know, again, a lot of that is going to be based on the relationship that you have with those defense lawyers, but you just don't want to be in a situation where your client's case is not being treated the way it should be because there isn't an expert report. And this again will come down to not only the relationship you have with the defense lawyer, but the discussions you've had with the defense lawyer about that value of your case that you see. So, you know, typically, if you haven't had the discussions before discovery, the discussions about the pros and cons of the case should really, really be held at the completion of the discoveries, because it's probably the most beneficial time where you're both in the same place at the same time to talk about what you're going to do next. And then when you're choosing your experts, make sure you're choosing the right experts, not the same ones every single time. We all know there's experts that write reports for plaintiffs and experts that write reports for defense. How about getting an expert that does a fairly equal amount for both sides? Because that makes that expert's opinion so much more valuable, as does how that expert has conducted themselves on the stand. Have they in the past done a really good job on the stand, or have they been you know, basically ripped apart on the stand and not deemed to be very viable as witnesses by the judge at the time? So really take that into consideration, as opposed to just going to the same people all of the time. And keep in mind, when you're looking at experts, are they going to make a significant difference on the assessment of your case? So are they going to smooth out wrinkles that you have in causation? Is that what you're hoping for? Are they going to, you know, make the difference between you getting $100,000 for your plaintiff or $200,000 for your plaintiff? Like, keep in mind what it is you're hoping comes from retaining them. Keep in mind they might come back with an opinion that's not helpful to you. And keep in mind the types of things you need expert reports for. I would see a lot of people surveying income loss reports. Frankly, that to me, unless you've got a self-employed person or some really complex uh, need for assessing the case, which often comes in a sexual abuse case, for example, because you have to go back historically and calculate amounts that were paid in wages, 40 years ago versus today and all that sort of thing. If it is a straight up income loss claim where the person has lost $10,000 a year for the last 10 years or whatever, everybody can put the McKellars or Baxter present value charts onto your computer. You can run those numbers just as fast as anybody else. So save the expense, save the time, and do it that way, because there's nothing that's more frustrating than a defense lawyer being served with a $10,000 or $15,000 income loss report that really is math that can easily be done by both lawyers on the file. So keep those sorts of things in mind. So when mediation is coming, another really critical step in the case, and something that I've said over and over and over again, and I don't know how many people listen. I did it as a defense lawyer and I do it even now. So, as a plaintiff lawyer, you must be aware that defense lawyers do not have the settlement authority. The settlement authority comes from their insurance client, and their insurance client has various steps they have to go through to get the authority. And they can't do it when you attach your expert reports for the first time to your mediation memo, which you serve a day before the mediation or a week before the mediation. Frankly, they can't even get the authority if you're serving those expert reports 30 days before. So defense lawyers have to do an updated assessment of their case for their client at the very least 30 days before a mediation, and more often 60 days before a mediation. And then the adjuster can use that updated assessment to set the reserves and to get their authority. So there's more levels than just going to the defense lawyer. That defense lawyer has to write to their client. That client has a manager. That client may have a committee they need to go before. That client may say, based on that updated assessment of this case, this one's now beyond my level and has to go up to the next level, which means a whole new person has to take a look at the entire file and assess the case. So the sooner you get everything that's critical to your case prior to a mediation to that defense lawyer, the better. If you're sending things within that 30 days of mediation, there's a really good chance, if those things are critical to changing liability or damages, that the adjuster is not going to have sufficient time to obtain the settlement authority. So the mediation is going to have a much bigger chance of failing, and again, wasting people's time, yours and theirs. So if there's a critical issue in your case and it's going to significantly alter the damages or liability or both, you've got to address that as soon as possible and get that dealt with. And, frankly, give the defense lawyer a call and a heads up and say, hey, like, I just received a medical report from my client's treating practitioner. They need surgery immediately. They're not going to be able to work for, an extended period of time, whatever. Something that's going to change that value is really important. So plaintiff lawyers need to be well aware that mediation is not the time for last minute information to arrive. It's the time for you to make sure you've got your entire case ready to go and that you've given sufficient authority to the defense lawyer and their client to make sure that they have the authority they feel is necessary for that case. When mediation fails, it's probably because of one of the problems I've just mentioned in terms of you not having provided the information in advance. When mediation fails, you have to look at how you've assessed your case. So are you and defense lawyer miles apart in terms of that assessment? Because if you are, then you will definitely need to take a really close look at whether something's gone wrong with your case or you've really missed the boat on part of your assessment. It relates to whether or not you've provided all of your relevant disclosure. And most importantly, was your position reasonable? So did you know what your theory was going in? Did you know how to make that theory? And did you know how to present the necessary information to corroborate that theory? So if you've done all of those steps and you're very firm in your belief about what needs to be about the value of your case and where it's at, then right after the mediation, consider serving a time-limited offer. Because keep in mind that that's the one day when the claims examiner is looking at your file and knows your file. So if you follow up that mediation on the same day or the next day with a time-limited offer, that's going to stay within their attention and might allow them to go and get some additional information, or perhaps they've reconsidered their position or they disagree with their lawyer, because often they disagree with their lawyers on the assessment of cases. And they might look to either take your time-limited offer or at least re-enter some renegotiation with you. And if that doesn't work, then serve your Rule 49 offer, because what are you waiting for? You want your costs to build up as much as they can, and that puts more pressure on the defense as well. Get your case ready at that point to set down for trial. So again, make sure that everything's been done, that you have no outstanding things to do, and set it down. And there's always going to be other chances to settle your case, but again, the faster you start moving it through the system, the faster those opportunities to settle come up. I just mentioned briefly, but I'll reference again. So important for plaintiffs to realize that who's making the defense decisions. It's not the lawyer. The defense lawyer is not making those defense decisions. That lawyer is making recommendations and providing assessments to their client, which may or may not be followed. And that happens more often than the defense lawyers would like. It happens more often than you would think. So really important that you've done everything you possibly can to present your case in a timely manner and with as much information as possible. And the real critical reason for why is because the insurers do audits. The insurers do audits on the files. And when they're doing audits, they're looking at whether or not there was missed chances for resolution, whether or not assessments were correct, whether or not their defense lawyer has done what they're supposed to do on the file, or whether or not their claims examiner has done what they're supposed to do on the file. So there will be whole separate audit teams that go through those files on a fairly regular basis, sometimes with the lawyer not even knowing that that's happening. So if you've got everything there, then they've got everything they need to look at to when they audit that file, and they might come up with a completely different opinion. It might result in a change of lawyer. It might result in a change of the claims examiner. And it might result in a change of what they were prepared to offer. So something to keep in mind that you probably wouldn't otherwise think about. So some of the best practices that I've talked about, just to wrap things up, are obviously securing those documents early before issuing the claim, communicating with the decision makers, whether that be the adjuster at the time or the adjuster once the claim's been issued. Try not to lose that opportunity. If you're not able to settle at that level, then, you know, have your documents ready to your affidavit documents ready to go as soon as you issue that claim. You know, ask for the defense lawyer to be appointed as quickly as possible, get your discovery date, and communicate with the defense counsel to get them anything extra that they need as soon as possible, as opposed to waiting for letters to be exchanged. Like I've said before, when you have all of that stuff ready, then you know your theory of the case in advance, you know the value of the case, you know your strengths, you know your weaknesses, so you know where to focus and how to address any of those weaknesses that you're going to be confronted with by the defense counsel. Again, take and invite all those opportunities for early resolution. If you're working with difficult opposing counsel, then just paper your file, build that file, move quickly to apply the pressure, because like I said, that person has to report quite frequently to their insurance client, and their insurance client's going to be you know, interested in what is or is not happening with the case. And ultimately, you just don't want any surprises with your case. So it's best that you know your case as much as possible before you open it up for the world to take a look at your case and find out that there's a whole bunch of other things that happened that you weren't prepared for. So I think that gets me to the end of my presentation, and if there's any questions, comments, or anybody else wants to add anything, then, you know, we can address that.
Thanks, Linda. So there's a question here. How often do mediation memos impact the insurer's view of the claim? Is the adjuster's settlement authority for the mediation already set in stone by the time mediation memos are typically exchanged?
So mediation memos, I guess the quick answer would be sometimes. So mediation memos don't always impact the adjuster, but if what I've been saying works, then there shouldn't be anything different in your mediation memo or anything unexpected in your mediation memo. So as long as that's the case, and as long as that defense lawyer has been provided with every single thing you were requested to provide and already did provide, then there shouldn't be any shocks. And hopefully that defense lawyer has assessed the case, you know, clear to, in conjunction with basically how you've assessed the case. If they haven't, there's always a chance that the adjuster has done their own assessment. Actually, there's not a chance. They all have done their own assessment. And they may have more in the tank than the defense lawyer does. You should also know that often the adjusters do not tell the defense lawyers what they have. Sometimes they do, but not all the time. So, you know, keep in mind that much of your negotiation at a mediation is with that adjuster, not necessarily with the defense lawyer. The defense lawyer is there to make the arguments. So I think that answers it.
Okay. What is your experience with an insurer refusing to authorize settlements before EDs?
I think my experience with that would be probably only in the context of a situation where the insurer has determined that the case should be defensible and that they're not prepared to pay anything to settle that case because it's a motor vehicle, for example, and they don't believe the claim will pass the threshold. So in that situation, you might as well move on to discoveries. But I would also say those are the most critical situations to ensure that you've got all of the necessary documentation. Because again, the more they have, the more they've got to look at, and the more that may give them reason to engage in a settlement negotiation with you. I have never heard of an insurer refusing to negotiate. I think that word might be not necessarily the one that would be used from the insurer's perspective. The insurer is just not going to engage in negotiation if they believe that your case has no value. So it's up to you as the plaintiff lawyer to make sure that you've provided the documentation to establish that it does have a value.
There's one more question here, and just a comment for people who have been inquiring that we will make a copy of this available, this recording available. It'll be available on our YouTube channel, but we will also send it out to the people who registered for the webinar. And so one more question, Linda, what are other things that cause a case to be determined defensible? Lack of documents to support claims primarily, question mark?
Yeah, that would be the number one thing, which is lack of documents to support the claim that's being made. So, you know, that's a situation where you may have to engage the experts. But again, I would suggest that you make sure you're engaging the right experts, not the ones that are used over and over, because if it's a report coming from a doctor that we've all seen a gazillion times, that's not going to change anybody's opinion whatsoever. I think in those cases, you also want to look at getting will say statements from family members, because family members, especially in those cases which are being deemed defensible, are really, really helpful. Family members, friends, employers, if possible, because if they can talk to what the person can and cannot do pre and post accident, that often carries a lot of weight at court, and we've seen that with decisions that have come out of the court. It also has loads of sway with a jury when they're hearing from real people talking about what that person could do before and after, and what they can't do after.
Okay, great. I don't see any other questions. So again, thank you everyone for joining us. This will be available for people who wish to watch it after or who were unable to join us today. So thank you so much, Linda. And again, thank you to everybody who joined us today.
Thanks, Brenda.